afternoon, everyone. Welcome to the 6th technical session of the National Virtual Conference on Economic Dimensions in Judicial Decisions. I'm Srijit SG, Executive Dean, Jindal Global Law School. This session is themed Economic Analysis in Public Health and Environment Domains. The search of law and economics as a method has brought in many insightful notions into the regulation of public health and in the global protection of environment. Concepts of externalities, costs, and efficient outcomes helped us better streamline regulative and legislative efforts. This panel will deliberate on such and similar influences and impacts for the next. The distinguished panel for the day comprises of Dr. Nupur Chowdhury, Assistant Professor of Law, Center for Study of Law and Governance, Jawaharlal Nehru University; Professor Dr. Tarini Mehta, Associate Professor, Jindal School of Environment and Sustainability; Professor Dr. Charu Sharma, Professor and Associate Dean, Jindal Global Law School; Ms. Krithika Subramanian, Policy Analyst, Cuts International. The moderator of the panel is Mr. Abhishek Kumar, Partner, Indicc Associates. Welcome to the 6th and the last technical session of this conference. Over to you, Mr. Kumar.
Thank you, Srijit. Really wonderful to be a part of this discussion. I was earlier scheduled to be a speaker, but happy to moderate, and which is a pleasure actually indeed, because this panel may be the last one, but I guess perhaps the most relevant one in the context that we are facing right now. So health has never been more important as a public policy area than it is in the wake of pandemic, which has kind of exposed all of us to the areas that we need to focus on. Which is basically human capital. So I want to say a couple of things before I really start out. One is that I'm very, very happy and honored to be part of this panel. And the second is that this panel also has 3 academics and 1 public policy practitioner. In my role as a moderator, I have also been a public policy practitioner, but I will try and chip in wherever I can with my experience and understanding of the subject. Also, what is interesting about this panel is that we have a lot of women. So there is often a complaint that gender participation in most of the panels is a problem, but I think we have a very, very good women-led panel. And I would request my panelists to also reflect on the inherent inequality when we speak about health and economics, where gender is an important component, which is often not mainstream as much as it should be. So without much ado, I just want to set the context, and also very, very grateful to JGU and Cuts International for organizing this discussion, because I think it's high time we started talking about the role of courts and the judicial system, which is not only the Supreme Court, by the way, it is high courts, the lower courts, and we have to have the judicial machinery work in tandem in an integrated way. So, and this is something that has been written about in the past. When you get into the literature of public institutions, courts, because of the power that they wield on lawmaking, play a very, very significant, important role. So it is also an opportunity to reflect upon the role of judiciary and judicial decisions in mainstreaming health, both from the public health as well as healthcare point of view. So thank you once again to the organizers for this timely discussion. The context that I want to sort of set out before we begin this discussion is about really the opportunities and constraints that we are living in. I think it would perhaps be appropriate to, first of all, send condolences to all those who've lost their lives due to pandemic, but also to acknowledge that there has never been a time in the past where health and some other fundamentals which directly affect human capital are critical, very, very critical. So the major paradigms that major narratives that we have in the country today, I think it's important to sort of reflect upon them. You have a country like India, which which has its own growth trajectory, and this growth trajectory is placed in the larger context of sustainable development as well. So not only do we need to industrialize and provide meaningful opportunities to the young population that India has, but we also have to do it in a way in those frameworks which were not typically applicable in the context of several other countries, because sustainable development as a discipline has also been evolving, and there are newer frameworks that we need to be bound by when we're looking at our development paradigm. So within the sustainable development context, we have also the duty to preserve and provide for public goods, and which is typically something that is often seen in the as a responsibility of the executive. When matters often come to courts, one will agree that the courts are under tremendous pressure because they have to look at the legal technicalities, but they also have to look at and must look at the larger justice that they seek to deliver, which may be in the context of how will it really impact number of people, the scale of operations, etc., which may have a lot of implications in terms of employment, in terms of larger well-being for the environment and public goods. So I think it's important to keep that at the back of our mind. The third important aspect that I want to sort of draw attention to is the fact that we are also, even without pandemic, we are also the kind of economic model that we have come to practice as a society, and I'm not particularly talking about just India, but across the globe, has led to increasing inequalities. And these inequalities are manifested in different forms, but the effect of these inequalities is something that is often felt when we suffer a shock, whether it is economic shock or a health shock that we are witnessing currently. The fourth important aspect, where we have often seen that legal technicalities fail to address this important aspect, is the availability of resources. This availability of resources can be seen again in two dimensions. One is what is available with the governments to really put out in public goods. Every state government is their financial resources are shrinking. Central government is fighting a pandemic war, but also the efforts to sort of strengthen the narrative on more equal society and generate resources alongside is a very, very big challenge even for the central government. So I think these four important points need to be sort of borne in mind when we reflect upon the judicial system and how one looks at health in that context. We've seen that a lot of narrative has also come around on the aspect that the way forward to deal with the problem that we're dealing with will have to be need for communal efforts. Every stakeholder has to come together and chip in with their efforts. Now, courts, which are part of the larger political economy environment, also often end up mimicking the same behavior as the larger society is part of. So one critical question that I would like my panelists to sort of reflect upon in their specific questions or at the outset is that how should a legal system take into account such a complex, such a wide gamut of things when delivering justice, because it is essentially bound by the legal technicalities, but also must look at the larger justice. So these are the 4 points that I thought would be appropriate to bring forth. My last important point that I want to speak about a little bit is that you have a lot of cases in the recent past and even earlier where we've seen a lot of debate that has happened around the role of courts and the larger environment that needs to be preserved and conserved. We have cases like iron ore case in Goa mining. We have cases like sand mining. NGT has sat upon several of the cases. We have emissions case where Supreme Court decided on, looked at public health dimension as well as economic dimension also. So we're increasingly seeing that more and more disputes are landing up at tribunal level, are landing up at high court level, are landing up at NGT level, and also for the attention of the Supreme Court. So, so this trajectory kind of says something very important. And that important aspect is that when you are developing in the framework that we are bound by, which is sustainable development framework, you are often going to have confrontation with some of those frameworks. So what should be the right balance? How should one look at these things? Is a court system, is a legal systems, are our lawyers properly trained to address that kind of a complex balancing act? So with that, I will open up. With that, I will open up my first. I'll put out my first question to the panelists. Is really looking at the trajectory of number of cases that have come around in the recent past, which is oftentimes we've seen that when a court which has environmental dimension and decided upon by the courts, we've seen that there's a trend of a blanket ban. You know, there is binaries that we've observed in the decisions. I'll give you an example. Say, for example, housing sector. Now, housing is recognized as a after automobiles, the highest a sector which has the highest multiplier effect in employment generation through the number of ancillary activities. But if you have a construction activity happening somewhere, which confronts with the environmental frameworks, does a blanket ban kind of an approach is something that is sustainable? Could there be alternatives that one can think about? So I think I'll begin with that fundamental question, and I would ask you to sort of also add more examples in your rejoinder or response to this question. So with that, may I bring in? I will go according to the windows that I'm really looking at. So there's no particular alphabetical order. So may I bring in Dr. Charu Sharma to begin with? Ma'am, floor is yours.
Thank you. Thank you so much, Abhishek, if I may. Yes, the context that you've sketched is definitely the most pertinent in which India is struggling. Public health, the crisis, the cataclysmic thing that we are all facing. And I think you rightly put it, that whether it is the judiciary, whether it is the policymakers, whether it's the union parliament, the parliamentarians, whether it's the healthcare workers, everyone is firefighting, right? And it is definitely, everyone is scared, and there's a need for a very strong leadership and confidence building. That's like, I just wanted to start with that. Confidence building, not only by the people who are governing us, maybe by also the judiciary in how they're handling the matter at the moment of COVID-19. There are so many distress calls going out every minute that the nodal officers who have been appointed in Delhi by the Delhi High Court for maybe a 40 group of hospitals, they are unable to do that. Whether our system has failed and whether we were unprepared for it are all questions gradually going to end up in the courts. Because the right to health, which may not have found a very specific written recognition in the Constitution, but has definitely been recognized under Article 21 of the Constitution by the Supreme Court, and very recently as well. So that right to health for every citizen is at the moment under, it's not there. If I'm breathing the air, I'm contracting this virus. It is no one's fault. but the fault might have been that we did not plan properly for it. I think all of us are agreeable on that. As far as the repercussions of this public health scare and the emergency that we are facing, it will go on to every sector, I believe. Not only socioeconomic, but people's mental status, people's motivation. If we are talking about well-being and sustainable development, we are definitely talking about well-being of the person, and then of the community, and then of the nation. So when we are looking at laws, and this is purely academic, because I'm an academic, when you're talking about imposing blanket bans, in times of emergency, your rights, fundamental rights, could be restricted. And probably the social distancing and wearing of masks and fining people who are not wearing masks was one thing which we have seen. And for that, on that matter, there have been so many skirmishes between people as well as the police. And the police are the only people who are, try to firefighting everywhere. So those kind of violations of a person's liberty and the government's right to impose certain restrictions on your liberty in times of emergency are understandable. However, if these matters and such matters go to court, and suppose the court comes out with a blanket ban, you talked about the construction sector. I'll just come to that in a bit. Then there is the sand mining sector. We can even talk about that. But I'm just talking about today and present circumstances. So if criminal cases come to the courts for this, then obviously the courts are going to look at it, not looking into it without any kind of economic perspective, but purely within the dimensions of the parameters of the law. And if law, they're going to try and then balance out the right of liberty that I have or you have with the pandemic situation and the emergency and the rightful way and the manner in which government has given out this this ordinance or whatever law or policy that please wear your masks and try and save yourself, as well as if you're not wearing masks, you're killing another person. So that's very serious. So the restriction like that is acceptable and should be acceptable to people, at least now when we are seeing death all around, utter chaos. As far as total and blanket bans and how do they impact people, whether they're socioeconomic, again, employment, unemployment, bankruptcy. Yes, that's a very, very important thing, which whether it is the Supreme Court or the National Green Tribunal, they have looked into these and have made and delivered judgments which are probably for that particular case. At the moment, you see a number of judgments having been delivered. For that particular case, they have gone over and beyond, I would say, not only examining the parameters of the law, but at times, and I think Professor Sudarshan said it once, that of course, when judges are making a decision, at times they've also laid down legal policies. So within that ambit, if I can say so, I'm just paraphrasing him, he said policy, but I would say legal policy. So say, for example, sand mining. You talked about sand mining. I'll give you an example. Sand mining and sand mafias are very common, and housing and construction sector does need sand and cement making and so on. Now, if specific regions have a specific reason and it is impacting this sand mining, illegal sand mining is impacting the riverbeds, and because of that, water scarcity is there, and because of that, irrigation is impacted, then what will NGT do? In these circumstances, NGT comprises not only of judicial judges, as in who are looking specifically into laws, but then the NGT also has experts. So these experts are scientific experts, maybe economic experts, and along the whole bench would then sit on a judgment and might ban a certain thing that this is not going to happen. Say, for example, what comes to mind, because I'm a Delhi person, what comes to mind is a total prohibition on, burning waste or burning stubble in and around the Delhi NCR. That there was a ban, total ban. Now, because of that, and because I'm staying in Sonipat, many students who were doing small projects came up to me saying, well, the farmers are not happy. They are not happy and they will not accept this ban, ma'am, because they say, well, this is the only way which is most convenient to us. We've been doing it for eons together, and this is the one which we know. Why should we invest in buying some technology to cut the stubble? And, we don't have that kind of money. They were told then that there are so many alternatives. So the NGT not only put this ban, but it came out with discussions that there are alternatives to that. And the government was ready to give loans and did give loans. So there's this chain of events which happen by a decision which is taken. And that decision has so many repercussions. But we cannot just, isolate or label the judiciary or the lawyers in not thinking out of the box. Probably, as an academic, one would say that, well, if you're only confining yourself to the law parameters, please understand that there are so many implications of your judgment. So this is the time when specialist tribunals, especially for the environment, are very, very pertinent. And the capacity building for these specialist tribunals, whether it's scientists, whether it's biologists, zoologists, or economists, in fact, becomes very important. So for me, when you ask me, even the housing sector, the court has provided a number of workable alternatives, like fly ash from alternative sources and thermal powers. So things are moving, probably, and this is not myopic. This has short-term and long-term implications. I think I'll stop here and let others join in what comments they might have. Thank you.
Before I go to the next speaker, it's a very, very interesting thing that you said and very provocative. And I just want to sort of take it to Dr. Tarini Mehta with a little bit of provocative angle to the same question. You said two very interesting things. One you said is we need more specialization at that level, but also because the trickle-down effect is so huge. It's a paradox that a specialist eye may ignore the subsequent trickle-down effect. So the intent of really asking a question of courts really taking something in a blanket form is to really, really look at that nuance. Dr. Mehta, I will be slightly provocative, and I will also bring in not just the court, but also NGT, and just slightly being provocative in the sense that should National Green Tribunal, in the context that Dr. Charu Sharma really spoke about, should also be actually National Systems Tribunal because of the interlinkages that are out there. And if you can also reflect in your response to the main question that I asked, the kind of competencies that are really needed in order to take that on. You're mute, so you'll have to unmute yourself.
Thank you, Professor Kumar. I hope I'm audible. I think I am audible. Right. So this is a very important issues that are being raised, and especially at this time when we're facing the pandemic. And in addition to the pandemic, we are facing some of the worst crises in humankind. It's going to be even worse in the years coming. I'm talking about climate change and the kinds of impacts climate change is going to bring, the kind of impact the biodiversity loss is already bringing. You have about 1 million species at the brink of extinction globally. So this is going to have huge impacts on human life on planet Earth. So in that sense, this is a very critical period. And of course, COVID is just, made very apparent to us that something is really going wrong, that, we need to do something in order to, in terms of systems, but also in terms of the way in which development is taking place, the way in which human societies are moving forward and progress and the markers of progress, and everything needs to now be reevaluated in many ways. So in this sense, what I want to look at is kind of turn the kind of go back to the beginning, in a sense, let's say, or to the original question that why do we even have environmental law? Why do we need environmental law? We have, property law, we have criminal law, we have, civil laws, we have all sorts of other legal systems. Why do we need environmental law? And the reason we have environmental law grew particularly in the 70s and so on internationally is because of the need to protect the environment. So then again, these are all basic questions, but it's something which we tend to forget in the larger debate when it comes to a particular project or a particular judgment of the NGT or the Supreme Court and so on, is that why protect the environment? Why is it important? Why not just continue on the way we are? Continue to cut down trees, cut down forests, build industries. Why? Because we need to develop. Now the question is that, is this actually development? Because the first one question then is, who is this development benefiting? Who is this development for? If you look at the progress and development in India itself, in our country itself, this development model has led to a huge gap between rich and poor. People in rural communities are continuing to suffer. Himalayan region is an example of this, where the rural communities in the Himalayan region, whether it be dams, other development projects, the benefits don't reach them. The benefits reach, people living in urban areas miles away, who are disconnected from the realities of of the impacts of these projects and so on in these very sensitive regions. So who is this development for? And if you are trying to raise the living standards of people, then we need to kind of also look at that and say that what is the standard of living? What is it? Are we just looking at it in terms of material progress, which is an important factor, but can you have, so for instance, COVID is an example of this. You have a house, you have a car, you have money, you don't have health, you have nothing at the end of the day. So that's where environment comes in. If you don't have clean air, you don't have clean water, you have food that you're eating is laced with pesticides, cancer cases are increasing because of this. Every day there's huge increases in cancer cases because of pollution of water sources. Groundwater is depleting. You're not going to have water, and so you have the water wars rhetoric, which keeps coming up that, in the future, water is going to be the next point of conflict between countries. So if you don't have these aspects, then can we call this development? And this is the direction that India is moving towards. This is the direction globally we're moving towards. Climate change is an example, the clear example of the fact that this development trajectory has not worked. Now the other aspect comes in that the developed countries have had sort of a head start on development, but at what cost? They've had a head start in development. Their model of development has become the model of development that the world aspires to. But on the other hand, they have decimated their forests, they have decimated the oceans, and today we are facing, serious issues of climate change. COVID itself is a zoonotic disease. So the connections between COVID and biodiversity loss also need to be kept in mind. So COVID originated because of an animal, because of a bat. Other species have also been connected with this aspect of COVID, but also it's because of biodiversity loss, because of habitat destruction. And the increasing biodiversity loss is leading to greater interaction between humans and various species. And so this element, now when you add to this the fact that climate change is going to lead to the release of many more viruses. And there's a lot of scientific research on this. Viruses trapped under the permafrost are going to be released. So we don't know what kind of the next 50 years, 100 years, what kind of a world we are actually bringing for ourselves and for the future generations. Because they're the ones who are going to be faced with a world where water is polluted, rivers are polluted, there's diseases, there's, no tree cover, you have oxygen bars opening up. Why should we have, if you think about these things, and in a way, because this is the kind of world we're living in, it's almost becoming normalized, but it should not become normalized. We should be questioning that why are we heading towards a world where you have to have oxygen bars? And it's a very cool thing, but is it actually? It means there's a crisis. These basic building blocks of life. So in that sense now, the role of the court comes in because of the fact that unfortunately our government, our administrative, the government structure, administrative structure in India has failed to implement the environmental laws. So there are a number of environmental laws in India. Even if those laws were implemented in itself, even if we don't talk about, the improvements needed and so on, just implementing the laws themselves industries need to set up sewage treatment plants. It's a simple law that needs to be implemented, but you have, why are the rivers polluted? Why are the groundwater polluted? Because industries are not setting this up. Now then you have laws in place for that. You have fines in place for that. The laws are not enforced. So this is where the courts have had to come in. And Indian courts, as we all know, have played a very progressive role, and they have actually set an example internationally as well, in terms of the right to life, the expansion of the right to life, which Dr. Sharma talked about earlier in terms of the right to health. So this expansion of the right to life is a very progressive, very creative expansion. And the thinking behind this was that, as the Supreme Court said, that life does not just mean animal existence. It doesn't mean just, to be alive. It means having a life of certain dignity. And a life of dignity means you have to have certain basic elements. So food, health, water, clean air, clean environment. So in that sense, the right to clean environment became a part of the right to life under Article 21. Now, in the same way, the courts have had to step in a number of cases. There are a number of historic cases where the courts have not just passed orders, but they've had to monitor the implementation of their orders. Again, because of the fact that the orders failed to be enforced and implemented effectively. The NGT then was developed to be a specialized tribunal in this regard to, again, focus on environmental cases. The reason being that environmental cases are so complex that you need a specialized tribunal in order to be able to deal with this. And ideally, that tribunal should have a range of experts in different fields and so on, in order to actually be able to come up with decisions which are have all the scientific basis and so on, because environment is an extremely complex field. And even in terms of, for instance, the application of a principle such as the polluter pays principle, if you don't even to understand, what is the extent of the pollution, what should be the extent of the compensation, that also requires a scientific analysis of the pollution levels of harm, and so on and so forth. So in that sense, the National Hearing Tribunal was an important step that has been taken. I think we're, it will be another discussion that we can take up here to look at what the NGT needs to be strengthened and so on. But the fact is that we need the court, whether it be the NGT, whether it be the Supreme Court, whether it be the High Court and so on, because of the fact that we need to protect the environment. So we need to kind of reverse the question backward. And the reason why we need to protect the environment is because we need to ensure a certain quality of life and standard of life for people. And that is the rhetoric of sustainable development. It's everywhere, sustainable development. But that's what sustainable development is meant to do. It's meant to be development that, while catering to the needs of the current generation, also meets the needs of future generations. So now sustainable development needs to be brought about. Now sustainable development needs a certain kind of policy approach, certain kind of planning. And if that kind of approach and that kind of planning is not happening, then where does a citizen go? A citizen will go to court and say that, I have certain rights, and those rights are based on certain needs. I have a right to life because I need clean air to breathe. So in that sense, I think this entire conversation and discussion needs to be we need to kind of go back to the original question of what are we doing? Why are we doing this? What's the purpose of this entire exercise that we are engaging in when it comes to environmental law and so on? Now, in the context of sustainable development, you have a lot of very positive examples. So the Nordic countries are a very positive example of sustainable development. They've been a leader in terms of sustainable development and sustainable, as well as in the happiness rankings and so on that come out. So in that sense, there are examples of countries that have made sustainable development a part of their planning, the policies and so on, and have actually implemented this. And this has had a positive impact on their citizens, on the standard of life, quality of life of their citizens. Of course, now the Indian context is much more complex than the Nordic countries, so it's going to be much more complex exercise. But it is an exercise that needs to be done, and in that sense, then the NGT, the Supreme Court becomes, watchdogs in that sense, to ensure that A, the laws be enforced, B, the basic needs of people be provided and be protected. And that's where they've had this expansion, where you have the expansion of the right to life, where you have the expansion of these laws in that sense, to ensure that there's greater human rights in this entire framework and protection of people and their interests.
Thank you, Dr. Mehta. I mean, before I take it to Dr. Nupur, it's my comments in the middle are just basically snowballing into making this question perhaps even more interesting, because the previous two speakers have already added some very interesting dimensions to it. But just on a side note, you did speak about science-based approach, scientific approach. We just recently held a dialogue at Rajasthan, where we placed, on air pollution. And I think one of the outcomes of the dialogue was that the clear message that I think in terms of technical detail, there is enough out there for everybody to acknowledge. What is really needed are two really important aspects, actually three important aspects. First, the resources, which are economic resources that are needed to be generated in order to address both public health and healthcare. The second is the role of institutions and how those institutions can play an effective role. And of course, the third was a multi-stakeholder approach. Taking it to now, Dr. Nupur, you have the advantage of coming in towards the end. The snowballing effect that I was trying to introduce to this is that the same question gets another added dimension added to it, which is that is the blanket approach often taken by the courts the reflection of the lack of capacity and not having the adequate ability to look at different components in detail and then coming to a more staggered, perhaps layered solution?
Yes, thank you, Chair, and thank you to JGU and CUTS for inviting me today. As you correctly said, Abhishek, I've had the advantage of listening to both Charu and Tarini and then coming in, so my job is a bit easier. I just want to start by making some brief comments before I answer your question. So the first thing is to reiterate what Tarini and Charu to an extent also mentioned, is that the whole point of this event is also, there is a presumption behind this event, right? The presumption is that the judiciary is not the best actor to take economic policy decisions per se, right? So under what conditions should they come in? And because it is happening, so what should be the conditions that would justify their intervention, right? So first, before we come to, before I answer that question, the first thing I would like to say is that economic growth per se cannot be the objective of any state policy. It has to be human development, right? And that, as Tarini rightly mentioned, that has both material and non-material aspects. This presumption that economic growth, leads to human development is a very weak one. There is enough economic literature that suggests that economic growth as a measure per se is very aggregative. It hides jobless growth, hides environmental destruction, and so on and so forth, right? And we are, just like the COVID crisis, we are also at the brink of a huge environmental crisis. So business as usual cannot be tolerated under any circumstances, which means that economic impact of not only executive and legislative, but also judicial decisions need to include long-term environmental consequences, right? And there is also this, we see it very quite often, that is there both within the legislature, judiciary, as well as executive, this idea that all environmental destruction is restitutive, can be restituted. There is an over-application of the polluter pays principle because of this presumption. And that is a completely false presumption, right? Not every environmental natural habitat can be restituted. That's something we need to all understand as a community, right? And therefore, there was this whole debate about go, no-go areas, right? When Jawaharlal was the environment minister at that point in time, right? And the second thing to also say as an addendum to this first comment is that environmental conservation per se makes eminent economic sense. Essentially, it is good to preserve the natural capital, right? And it ensures long-term economic growth and development. So this is not a binary at all, right? My second comment is briefly that because that was what the concept note seemed to suggest, that judges should not be economic actors or actors taking economic policy decisions, right? So I agree with that presumption that judiciary should be an adjudicative body, right? The basic function of the judiciary is to adjudicate disputes. But because there are basically two reasons, one historical and one just the way the setup is done. One historical reason is that we've always had judicial activism, and therefore there has been, through the public interest litigation movement, the judiciary has come into the policy space, right? And the second aspect is that in many instances, the judiciary has had to do that because both legislation or policy has been unclear, and therefore that gave them discretion to interpret provisions in a certain way where two or more choices could have been made vis-a-vis economic, right? Which they have done so, right? Now, given this presumption, this thing is to ask, the question to ask is that under what conditions should the judiciary, so general condition is that judiciary should not be an economic actor, and deference need to be shown to the executive and the legislature, right? And this is even more true for the NGT rather than the Supreme Court and the High Court, given the institutional structure of the NGT as a tribunal, right? But under what could be the conditions which would justify, so what would be a justifiability standard for the judiciary to intervene, right? I would suggest that there are two conditions that needs to be fulfilled for the judiciary to come and intervene. One is when it would be, one can say that there is egregious violations. So there is massive and sustained statutory and constitutional violations, and also violations of the court's judgment and orders. And I'll give you two cases in which this has happened, because these cases were highlighted. Both the Mopa Airport case and in the Deepak Kumar case, which is about mining. In both these cases, the first response of the judiciary was not to ban. In fact, the response was to actually give more and more time to the executive to come up with solutions, right? And they, first of all, the judiciary was able to establish that there were massive violations, statutory violations, which were compounded by the fact that judicial orders were being violated. So if you look at the trajectory of the case, all these cases have been heard for more than 5 years and more, right? So the ban comes in only after half a decade of hearing. So that one needs to keep this in mind, when one tries to suggest that the ban is the first response of the judiciary. It's never the first response of the judiciary, right? So the second thing is that, and one condition being massive and sustained statutory violations, and second would be, I think one aspect in which the judiciary should intervene under one condition is that when there is great environmental or health disaster that is impending, right? So under these two, if these two conditions are satisfied, I think there is a very good case for the judiciary to intervene and to actually suggest economic choices, right? Now, I think I would just as a addition, I would like to mention that I am not a very good, I don't believe, let me put it like that. Let me make a more reasonable comment. I'm not a very good supporter of the suo motu cognizance by the NGT specifically. I find it very problematic, and I think it's a very important issue under what circumstances you are taking suo motu cognizance, and for what purpose. Because what has happened with the NGT suo motu actions, at least, that there is and this has also happened with Supreme Court to an extent, but it's a constitutional court, so one can at least give it more liberty. There has been an occupation of the field, I would suggest. So that we see in Godavarman. It's a great case for that, where you've basically taken over the entire forest governance of the country. The NGT has done that similarly with environmental accident cases throughout COVID. Essentially, you are becoming a governance institution, you are replacing the executive. That is what has happened. And I think this is very problematic because with suo motu cognizance, there is a complete silence of who is an affected party. So suo motu cognizance is happening along with the fact that there are affected parties coming and putting in their petitions, but entities also taking suo motu cognizance. So because the whole institution structure of suo motu cognizance, the rules are not clear, I think that has a very problematic impact. So my last comment is that if one were to agree that under certain very specific conditions, we accept the judiciary should intervene and make choices which have economic implications, what should be the standard of review? I would like to suggest that there would be a procedural aspect in which the judiciary should be looking at ensuring fidelity to the EIA procedure, which means that the kind of review that the judiciary needs to make is a fine tooth comb review, is a thorough search and scrutiny of the EIA process. So the EIA authenticity of the EIA report made by the project component, was all aspects considered by the EAC and the SEAC? The reasons were there reasons given for the decision, and what is looking at the public hearing procedure? This is what the court needs to do in terms of a procedural review. In terms of a substantive review, I think the court has done that in certain cases, like where, example, in the NGT, for the NGT in the Sudeep Srivastava case, it has said that sustainable development as a principle, if you want to apply as a standard of review, you need to look at equitable access to natural resources, public participation in environmental decision making. These are important aspects, and I think what specifically the NGT has done, because it's possibly it could do it because the principle of sustainable development, as along with precautionary principle, is also mentioned, and the polluter pays principle is mentioned as a principle to be applied. So they've actually developed the jurisprudence around it. The other thing is the carrying capacity. So the NGT has looked at at specific instances, looked at the carrying capacity, and therefore instituted a ban. So bans have been local. First of all, this idea should be challenged that bans are national. There is no national ban. Right? There are local bans, and that ban was given after a long hearing, after establishing that there have been massive violations and it is beyond the carrying capacity. Right? So that's something to be kept in mind. Finally, coming to your question about, what should the NGT do? I mean, in terms of, I think I agree with Tarini. NGT is, is institutionally more capable of looking at environmental disputes specifically, which have economic policy implications, than the Supreme Court, or because it is a body which has experts. And if you look at how the jurisprudence are developed, it has taken in independent testimonies of experts. It has set up committees which look at fact finding. So there has been substantial institutional innovations by the NGT to respond to this question that what if you don't have the expertise? What do you do? Then you go beyond your own institutional in-house expertise and look at that. And that's something that the Supreme Court and the High Court have also done through amicus. So I think, just the first question, basically that's my intervention to begin with. Thank you very much.
Thank you. I think these opening remarks have given us enough food for thought and has provoked me definitely. I would just like to sort of react very briefly on this, and then keeping the time also into consideration.
I'm sorry, can I just add to what Nupur said? Nupur, thanks a ton. Abhijit, just give me 2 minutes.
Yeah.
Just wanting to add to, very rightly, Nupur has brought out the nuanced things which one ought to be seeing. But the question, I think, going back to the whole conference theme, what are the economic impacts of judgments, and whether the judiciary is mindful of these economic impacts once it makes judgments, whether it's the NGT or whether it's the Supreme Court and the High Courts. Probably all of us would agree sitting here in the panel that there have been cases wherein, and recent cases, not going even back to 15, 20 years, 3-4 years ago, most of the judgments in respect of environmental law, or even in respect of just specific application of tax laws, at times the judicial benches have gone into an analysis of economics and law. It is not that they've been unmindful of the economic impact. Rather, in fact, in the very often cited case of Shiva Shakti Sugars and Sri Renuka Sugars, this was the case wherein Mr. Justice Arjun Sikri delivered a judgment where economic considerations and impact of closing down or refusing to allow a sugarcane crushing factory to operate was like kind of debated. And here the court not only refers to the economic analysis, which Richard Posner, or to Ronald Coase's the Western economic analysis, which some might say it's absolutely not applicable here or we shouldn't look at it. Even so, it is not that the court has not gone into an economic analysis and economic impact in what Nupur was talking about in cases where the courts have very, very clearly, whether it's the NGT or even the Supreme Court, not looked into the EIA processes. Like the Society for Protection of Environment and Biodiversity 2016 case, the court has looked into the law, severed out the law which was bad, looked into the principle of non-regression, and also looked into the economic repercussions for giving an environmental clearance for building and construction projects. So one can't say that the judiciary are totally unmindful of the economic impact. I think the larger question, which I'm sure, Abhijit, you are going to come about to us, is whether within this context, the judiciary should be sensitized, and when there are projects which come to the judiciary through a PIL, whether there should be any kind of economic impact analysis already available to the judiciary to be able to make decisions which, will have an economic repercussion. Doing an economic audit might come later, but probably capacity building, that's what I said. So that's what I wanted to say. Thank you.
No, thank you. Thank you very much. I just want to sort of reflect upon what has been said so far. And in the interest of time, the subsequent questions, we will try and make it 2 minutes each response. Just a couple of things. In my own research around economic impact of court judgments, Supreme Court and otherwise, one thing has really come out, and this is also coming out of this discussion, which is that on similar matters, the judicial principles do not have consistency. You mentioned Shiv Shakti. Shiv Shakti is an exception. Majority of the cases in the recent past that I am about are not seen in the same way as Shiv Shakti is. Number of questions. Shiv Shakti, I think the economic impact in question was about 300 crores. When you look at other cases, you were talking about 1,80,000 crore and humongous costs, and not just the direct costs, but also costs which have a trickle-down effect, as Dr. Sharma, you rightly said, on banking, on employment, on a number of other things. So I think one of the important things that is coming out from this is that the nature of the cases, and there needs to be this exercise that the nature of the cases, common judicial principles do not exist. There is a high degree of variation in how the court treats each case differently. And actually that can also be seen in how lawyers, same lawyer representing different cases, have a different argument because they are actually representing a particular client. So this is a structural issue, and I think what can perhaps help, that can be a question that you might want to answer, is how to develop that consistency of judicial principles. One very quick remark on Dr. Nupur, you said that ban is not really the first instinct of the court. That again stands challenge. If you do look at the emission bans case and BS3, BS4, you have two things that can be questioned about when the economic impact is concerned. One is that enforceability, because if the intent of the court was to really prevent emissions, then it failed to do so. The second aspect that is there is that the entire judgment was in the context of public health, and only emission component was taken up. But the auto fuel policy very, very clearly talks about 4 other components to reduce emissions, which are related to governance, which are related to the structure and design of the vehicles, etc. So you're taking out one component, going out to look at that single component while 3 other components are ignored from the same policy that is challenged over here. So anyway, so these are open questions that we have. I'd like to come to a very, very fundamental question before I come to the processes. And processes of assessing economic impact is I think, well stressed point, everybody has emphasized upon it. But a very fundamental question before that is that...
Mr. Kumar, if I may interrupt you, I had a few thoughts and I thought I'd just share it with the panel.
I'm bringing you in, right? I'm bringing you in with this question on the content. So first is EIA, SIA, and EIA, economic impact. Why? The larger sense that is coming out from this discussion so far is that environment subsumes almost every other interest, right? So will that not be putting blinders and looking at something in silos, whereas the need is to look at something holistically and assess the larger justice? And this is where I want to bring you in, Krithika, because you have been analyzing a lot of these cases which actually deal with these larger questions. Yes, Krithika.
Thank you so much. Am I audible?
Yeah.
Yes. So I just wanted to first just a few reflections on the points that Dr. Sharma, Dr. Mehta, and Dr. Chowdhury made on the previous question on looking at different challenges. And one of the things that I wanted to point out was the study that was being carried out by Cuts International. One of the studies that we were looking at aims to sort of objectively assess the unintended economic impacts through an evidence-based analysis and also a detailed consultation with different stakeholders. So two of the projects that I was involved in was the Goa iron ore mining and also the sand mining case in Gautam Buddha Nagar. So the aim was to sort of take into account the ex-ante estimates of the economic impact of judicial decisions using a systemic and sort of a structured process. The idea was to foster a discourse on broadening the considerations that courts could possibly take into account while making a decision. So just sort of moving in specific focus to the sand mining case. Most countries, what happens is that sand mining is officially regulated through a national mining and environmental protection legislation, with authority for regulation devolved to the state or the district level. Legislation is usually accompanied by non-binding guidelines to improve the sustainability of the activity. This governance structure sort of ensures that many small administrative entities have responsibilities for implementing and enforcing these regulations. The lack of these enforcements of regulation in India is a common issue that we have found through our case studies and analyses. There's also an inherent push that I have noticed that the government needs to take on sectors like the construction and the infrastructure development industry, with sand being used as one of the main components for the extraction from rivers as a core material in the construction and development industry. It is having a severe and widespread impact on its rivers and coasts, as mentioned by Dr. Mehta. The construction industry needs to be slowly weaned off the river source aggregates, either through substitution of materials or alterations in building designs and methods so that extraction is reduced to a minimal. This will ensure that there is a minimal negative impact on the environment and the ecology. This type of a societal shift that I believe is similar, that is required to address climate change, that will necessitate changes in the way that sand and river is perceived and that cities are designed and constructed. This is broadly these are the thoughts that I had that I thought I could share with you and perhaps hear from the other panelists as well.
Thank you, Krithika. I think we're moving towards second fundamental question. I think the first segment itself has been very, very thought-provoking. I would like to go back to the question on the point on regulation that you spoke about. Now, Supreme Court in particular, or courts in general, like to take mostly a very conservative view when it comes to intervening anything that has come from a regulator, precisely for the reason that regulatory bodies essentially have to have the expertise that is needed to handle the sectoral complications, right? If you are talking about if you're talking about regulatory bodies and regulations not being adhered to, and that's something landing up in the court, then we are really opening up a very important fundamental question, which is that in the first place, when the courts take a very conservative view, and only rarest of rare cases where the regulation is challenged, when it lands up in the court, the court's deciding upon it, and the so critical question that comes in is where this is. I would like to also bring in Dr. Charu Sharma, that there is an implicit admission in this process of the lack of capacity to deal with different complexities, economic, health, environment, and all kinds of complexities. So what should be the ideal process that the court should actually follow in order to have a better, more informed adjudication? Question for the panelists. Dr. Sharma, can I bring you in?
Am I audible now?
Yeah.
Yeah, okay. I think, Abhijit, you're a policy person, so you've kind of taken the discourse in a very, I think, tangential way, going about questioning, if you're questioning what the judiciary should be doing when it is looking into regulatory dimensions.
That's not the question that I had asked. The question that I'm asking is that there is a convention in the country. I'm taking off from where Krithika had left. And Krithika has said in most of the cases that where she has studied and Cuts International is working on are the questions at the intersection of law and economics, wherein most of the times what is often found is that the regulations have not been adhered to, right? In general, the principle is that since regulations are housed with the necessary expertise, and that is the reason why courts really do not interfere or are averse to taking up cases where regulation has not really adequately responded. So in very rare cases, in my understanding, only 2 cases where regulatory decisions were challenged in the recent times was a cryptocurrency case and the court of judgment. I have not seen any other case that has come out of the regulation that has been challenged in the Supreme Court.
I think in context, we are talking here when we're looking at either the public health emergency or we're looking at environmental dimension of maybe a regulator. Now, Nupur just talked about the way the Godavarman case was taken over by the Supreme Court. Supreme Court sat in as a governance body. Almost that administrative function is being taken up by the court. However, having said that, if you're looking to, I would agree that if there is a dimension, especially in environmental and ecological cases, where there is a research body or a cadre of people who can add to certain dimensions of certain projects, which are maybe referred to it by the central government or the state governments. And if there is enough research, when the question of regulation or regulation being violated or not enforced goes up to the court, as I said, that there is enough material ex ante for the court to consider, to call upon the consultants, that could be very, very, I think, productive and beneficial for the court to do its job then. The job being, here we're not looking into what is the economic impact, what is the job being at the moment, whether the law and the regulations have been followed. If they've not been followed, the reasons we know, now maybe we can provide a direction. So probably creation of a cadre, like we have the Indian Forest Services, we have the Indian Police Services, and I've always been very, very eager that there is suddenly, like Tarini was saying, if you don't care about the environment is killing you. We see this today. COVID is hitting everyone. Environment, it is a long-term thing which you should be working about. So the small-term issues, small-term steps that we need to take, if I may say so. And along with that, the judiciary and the other governance institutions, probably maybe a creation of a very strong cadre of research scientists who have the capacity and who keep on working, like the CUTS is working, like the Vidhi policy centers and so on and so forth are working. That information should be made available to the court, where the court and such institutions, the court can call upon the material and the research so that they're already forewarned, they understand, and then they probably go on. And which the court does, mind you. I'm not agreeing with you totally. The court does it. And in fact, the earlier laws, I remember reading the object and aim of a particular law, there used to be some kind of an economic impact assessment kind of a note always attached to the aims and objectives of a particular law which was enacted. So the judges had the benefit of reading that and then determining what is the larger objective of the law. So if nowadays, of course, it's missing. We keep on looking into the archives within the discussions and the debates which happen in the parliament, and oftentimes the economic impact of a certain law would also be missing as to how much money the law would have, how much money is the government going to put into making a law. So that dimension is missing. So if all this is considered then by policymakers, probably the job of the judiciary might, they'll have a better sense of where they'll be ending by giving a particular decision in a particular case.
No, I think very valid point, and you've raised a very, very interesting point, and this is actually the question that we should all be tackling right now, and I'd like to take it to all panelists, is that we earlier spoke about consistency of judicial principles on a similar matter. I think that's a need of the hour. Some kind of research analysis needs to be done on that count. The second is the same courts in some cases refer to a committee or a set of researchers or experts, but in other cases do not while arriving at a decision. So Dr. Sharma really kind of already mentioned the framework that this needs to be seen through. Let me take it to Dr. Mehta, followed by Dr. Mathur and Krithika to reflect on the same proposition, please.
So the main issue that we are kind of having to deal with, and the reason why this is happening, why these debates are also taking place now, is one is, of course, this has always been there from the time that the Supreme Court and its activist jurisprudence with regards to the environment, that perhaps the Indian judiciary is too activist, and so there's been this constant debate. And yet on the other side, we've had the arguments that there was no other choice. They filled the gap in terms of environmental governance. They expanded jurisprudence which protected the rights of people and so on. So you have this debate has been active for several decades now. The NGT has got added onto this debate at a time when you also have the government trying to weaken environmental laws, and we see this with the environmental impact assessment norms, where you have the government trying to open up various sectors, in the mining sector, for instance. And so in the midst of all this kind of a focus, of course, in order to economic progress is the main aim, and then with COVID issues and economic losses due to COVID, this pressure has increased. So you have more pressure now being put on natural resources. And now this debate has come around the NGT. Now the NGT, it's a tribunal, but it does have one of the aspects is that a case, particularly if you're looking at a regulation has been violated. The environmental law, in other words, has been violated. The Water Act has been violated. The Air Act has been violated. The NGT has the jurisdiction to look at that particular violation. So that is the more simpler, according to me, issue. The issue which becomes deeper is then how should they respond to those kinds of issues? So the blanket ban, sort of what you were talking about. Should there be a blanket ban? Are they the correct body to be imposing such major decisions which have an economic impact? That's so that kind of aspect is coming. And so when a law is being broken, it's much easier. There's a law. An industry has not put in place a sewage treatment plant. It should have done this. The law is broken. This is much easier. Now, what do you do with major hydropower projects? An EIA for the hydropower project. And there have been a number of interesting cases come out of the NGT where different types of decisions have been taken by the NGT. So in the case of certain hydropower projects where the EIA was flawed, the NGT has set aside the environmental clearance. In the case of other hydropower projects with similarly, flawed different aspects of the EI process, EI report being flawed. The NGT has not set aside the environmental clearance. And very often when it has not done it, the reasoning given is that this project is important for development, for national, in terms of the development, in terms of, for instance, the Renuka Dam and so on. So now this becomes another question to, these are the kinds of tricky sort of decisions which the NGT has to take, in this context. How do you balance environment and development? Now, in this context, what I want to bring into this debate is also the aspect of, again, trying to look at this issue from a broader angle, because I kind of feel that if we look at it from a broader angle and we kind of keep the end goal in mind, then we'll also be able to understand or be able to come to some sort of a preferred approach or a better approach or some sort of a beginning of trying to understand how should the NGT, how should the government, how should anybody that is dealing with the environment deal with the environment, So now in this context, we have the economics and we have the environment. And now one of the problems which was, is this sort of that these two are seen as being separate, two different boxes. You have the economic gains and losses, you have economic progress in the environment and the kind of debate and that has been there for decades, which is why we're in the position we are today, is because it has become, even though it is not said so much, the rhetoric is sustainable development, but the underlying belief is that you need to sacrifice the environment for economic progress, and that it is all right to sacrifice the environment, that it is, normal, it is all right, we normalize this, But actually, first of all, that is, an extremely flawed view because of the fact that you can't, as I already said, you can't have progress and development if you're sacrificing the basic building blocks of life. So you're sacrificing quality of life. Now, if you're looking at this from the point of view of ecosystems, right, and the services which an ecosystem provides. So as an adjudicator, whether it's an NGT, whether it's a policymaker, whether it's someone sitting in the looking at an EI report and deciding whether a hydropower project should be set up, the consideration has to be broader. It has to be in the point of view of now this particular resource, let's say a river, the hydropower project is being set up. This particular river provides a number of ecosystem services. Those ecosystem services include provisioning services. So the provisioning of for instance, water, irrigation, hydropower, all this is provisioning services. It also has regulating services where it plays a role in regulating various, key basic elements related with biodiversity in ecosystems, without which you can't have ecosystems, without which you will ultimately not have the river itself. And then it also has a role to play, ecosystems have a role to play in supporting services, in supporting the ecosystem itself, and cultural services, so the spiritual, aesthetic, recreational values, which river, for instance, in this case, provides. So now, as a decision maker or policy maker, you need to be able to look at a resource and say that this particular project, this hydropower project, is going to provide this level of economic benefit, but also there is going to be losses because of the impact, the environmental impact of that particular activity on that resource. Those losses are going to have other impacts. So those losses are going to impact the regulating services, the supporting services, the cultural services. Now, some of these services that an ecosystem provides are irretrievable. They're irreversible. And
Dr. Mehta, if I can direct this, all very valid points. Would you recommend a process that perhaps courts can actually follow, which has had a proven acceptance by the judicial system as well as yielded positive results? What can be that process?
So in terms of courts, the process that they need to follow and the process which they to different levels of degrees of success they have followed, in some cases they haven't. But again, the problem which the NGT faces in terms of this process is that environment is extremely complex. You need to have then a very varied expertise, and that is something which
multi-stakeholder research.
Exactly, plus the actual expert members of the NGT itself need to have those different levels of expertise. So that is one of the challenges when it comes to such cases. But then from a broader point of view, this kind of an approach needs to be there, not just at the NGT. So what I kind of feel is this debate needs to move into, in that sense, your area, the policy area, that we ultimately need to, the court should, if you look at it from the other point of view, we should not have to go to the court. If you see that as a point, why should we have to go to the court? We have environmental laws, we should have processes in place. The courts should be the last resort. They should not be the first resort, but they are, which means that something is also going wrong at the policy level. Now, at the policy level, then these ecosystem services, etc., all this needs to come into a strategic environmental assessment approach at the policy level, where all these projects will be looked. So in that sense, economics should not be seen as divorced in that sense, or this kind of a debate where economics is environmental decisions are impacting economics, whereas actually sustainable development means that the three.
I may have to come in. No, point well taken. Absolutely, all valid points and well taken. I may have to come in because we have to ration the time. We have some students who posted questions. I'll come to Dr. Nupur. Briefly, Dr. Nupur, if you can reflect on the question, what processes can be followed by the courts to have a better balanced judgments, which takes into account economics of it, but also the social and environmental mandates?
Yeah, so I think 2 points. One is that what was suggested to us as one of the things that was that we were posed as questions was that should there be a formal economic impact assessment report that should be provided before, to the judiciary before such a decision when they're considering such decisions. So my thing is that my response is that firstly, the economic impact assessment de facto is already there within the arguments of the state and the project proponent. If you look at all the judgments, de facto they do make the economic impact. Their whole point is, if you look at even by the kind of claims that are submitted, the admitting that they have violated environmental provisions comes much later. Firstly, you will provide the idea that you have a huge economic impact will be felt if the project does not go ahead, and then comes the admission that there were environmental violations. Right. So that's already, although not formally, but that's already part of the judicial process, I would say. Now, economic impact assessment as a formal process, the cost-benefit analysis thing was mandatory by the Planning Commission for public funded projects. And that was done away with when we went into the PPE, the PPP kind of project area. Now, the question is that the problem is that who will do the project? The problem with the EIA report is precisely that. Who does it? The project proponent is paying for that. So who will pay for the economic impact assessment? Are you asking the state to do it, or will the project proponent be doing it? And then the fundamental question is that also that it is again an aggregate, it's of an aggregative nature, no? You're not going to disjoint. And is it going to be in the form of an affidavit? Because the EIA is kind of an affidavit report, because you have an environmental management plan post the approval of the project that you have to follow and justify, right? So you're actually reporting on what would be the environmental impact. So, the nitty-gritties have to be looked at. But it's a good idea actually, but I think it's very important that in fact of de facto making a larger, very vague ideas about economic development or from a project triggered by a project, you make an affidavit and you say that I think this A project is going to have this economic impact. Right? I think it's a good idea to have an economic impact assessment of a project, right? And but the problem is not about. It's always the M&E part, which is been the Achilles heels of environmental law. You see, it's the monitoring and enforcement. So if it's in a kind of form of an affidavit, you need to ensure that the project proponent actually follows through, right? So the other aspect I would like to talk about is, the question that was posed to us about the economics of polluter pays principle. We have a CPCB formula which is supposed to calculate environmental pollution, the damage for environmental pollution, which is now being applied by NGT across all the cases. From 2019 onwards, that formula has been. But there has been no discussion of the formula. How did you come up with an approximation of these values? right? Moreover, again, even if you apply that formula, is environmental compensation actually reaching affected people? We have no evidence on the ground of that. So you collect environmental compensation, but there is no disbursement of that compensation, right? Because again, monitoring and enforcement is a problem, right? Finally, the other important, interesting question that was asked is that should CAMPA funds be directed towards COVID crisis? Now, CAMPA fund, this has been a problem with all funds that are being collected for environmental restoration. So you have the District Mineral Fund, the CAMPA fund. There has been huge pressure from the executive to divert the fund for all non-forest purposes in a certain way. So nature conservation is never used for nature conservation. There is a lot of pressure, political pressure, to divert it. So I think it may create a bad precedence if you are going to accept that these funds, which are meant for nature conservation and environmental protection, is diverted for other purposes. So it may create a bad precedence. But given that, I think it is interest. One could imagine that if you were to use CAMPA funds and give it for to Gram Sabhas for their forest management activities, that would have a massive livelihood impact. It would stop. It would provide for livelihoods at that rural level, and that would reduce migration. So one can reimagine that. But per se, my first response is that one should not divert funds, which has been happening. Okay,
yeah,
and sorry, I know. Okay, sorry, yeah.
This is very interesting because a lot of places the funds are there, but they are not actually even utilized, right? District Mineral Fund is one example, and health, it can be actually effectively used for health for the mining victims. I have questions. It will be disservice on my part if I do not let some younger minds participate into this discussion. And we will do a rapid fire, a minute each. We will take up 3 questions, and because we are also rationing time. The first question, I'd like to actually begin this with Krithika, a younger colleague, and then we will follow the reverse flow. So the first question is, can we expect a judicial federalism or a uniform judicial order in the situations of emergency health crisis? For example, various high courts are entertaining multiple PILs on similar emergency health concerns at this juncture. Very quick response. Krithika?
So, can you hear me?
Yeah.
Okay. So I think the pandemic has been very damaging, and it has also opened the eyes of the people for the importance or how pertinent it is to have universal and robust public healthcare systems, and the need for everybody to be covered under this system. The situation today across the country is that despite public health being historically understaffed, under-resourced, they've also really stretched themselves to meet the needs of the challenges of the COVID-19 pandemic. Kerala is one example where the public health services have done a remarkable job of containing the spread of the pandemic, especially through their primary healthcare systems. So perhaps the pandemic will play a role of a catalyst in leading a change in people's perception, and that can also lead to a rejuvenation of the public health services, because political will flows through the public. And if the public takes a greater interest, then obviously the governments will also have to respond. And just a digression would be also the budget. Although around 3 to 4% of public healthcare and publicly organized healthcare would be a good starting point to put in place at least a basic kind of universal healthcare system. The 15,000 crore rupees allotment that was given by the center for the health sector that was sanctioned along with the first lockdown is a welcome step. My only point is that a little bit more was needed in the routine annual budget of this year and those of the last 4 years. Just my final concluding point would be a point that the Delhi High Court had made, which was that just because someone is poor, the state cannot allow him to die. After all, health is not a luxury and should not be the sole possession of a privileged few. Thus, I think it's the responsibility of different arms of the government to keep in check and balances of each other and to closely monitor the extent to which prices of medicines, vaccines, and medical services are reasonable. If evidence points to the fact that cost is an impediment to access of resources, judicial bodies really need to step in to set the situation right. I think I'll pass it over to other panelists and hear out their thoughts as well.
Dr. Mathur, we're doing the reverse order. You may come in first. A minute.
Was that for me?
Yeah, so we're doing the reverse.
Okay, sorry. Yeah, I agree with Krithika more or less. I mean, my first impression is that I think high courts are very important at this stage because they are much closer to the ground than the Supreme Court. But I think there is a role for the Supreme Court not to supplant the executive, but to make it accountable in terms of huge equity issues are there at stake right now. Just the vaccine pricing issue itself. So I think that is an issue that the High Courts can't deal with, but the Supreme Court is very much within its remit to deal with right now. So I think that's important.
Dr. Mehta?
Yeah, so I think again now this brings us back to the interesting role that Indian courts have, keep playing or have to play. The COVID crisis is an example of again various aspects of administrative failure, government failure, policy issues, the vaccine pricing, and so on. And so the court stepping in, the Supreme Court taking suo motu cognizance, and Supreme Court saying that high courts are better equipped to deal with these cases because they are more, they're in each state, so they can kind of respond to the problems in that state. But again, this is something which it needs to be dealt with. Again, finally, the decisions, the policy gaps, and so on need to be addressed so that we don't have courts having to take this. My main point is that the fact that courts have to step in, whether it be the COVID crisis, whether it be the environmental crisis, shows that there's a huge governance failure taking place. And then these issues cannot be solved by courts ultimately. There's just decision will be taken, but ultimately there's, the governance gap, governance failure is going to keep coming up in different forms. And now with COVID, it's a huge human rights crisis taking place. It's a medical crisis taking place. And that needs to be addressed by policy, by government.
Sure. Dr. Sharma, same question.
Thank you, Abhishek. I think the question is very pertinent. Why is there a confusion in everyone's mind who's sitting right next to his phone or on the laptop and reading the news or listening to the news? The media is showing what it is showing, and the question probably was answered itself by the Honorable Supreme Court in the proper treatment of COVID-19 patients and the suo motu case which is going on. Public health is a state matter, right? So Delhi High Court or Karnataka High Court or the Bombay High Court, they're best equipped to deal with the matter at hand. The Supreme Court taking its constitutional duty to kind of provide a bridge and direction where there is none between interstate exchange of information, interstate transport, railways taking the oxygen tanks along. There's so much to do. It is not only between the center and the state, but it is within the state itself. And that is what the Supreme Court and each of the High Court probably and the district magistrates are doing at the moment. That is providing the mechanism, providing ease of access to the raw materials or to the oxygen or to the medicines which are there. And that's why it's very pertinent that the courts have taken up their constitutional duty. They're trying to do best firefighting. Of course, there also there is, as Professor Mehta said, and I think others as well, there is a failure on part of not planning the disaster management action plan in respect of COVID. And the failure, of course, is not, I wouldn't say that it is entirely upon the government. It is people who have also, violated the norms and gone ahead into crowds and markets and so on and so forth. So there is a lot of things which are required. And first of all, I think it is people like us who need to abide by certain things. If we have to stay at home, we stay at home. And if the others are doing their job, we should be helping them in doing their jobs. Thank you.
Yeah. No, thank you. We have several more questions, but we're also running out of time. You also said that what should be the responsibility of people? When you think of the polluter pay principle, you always, one thing is, okay, enterprise dimension, but we often forget the consumption dimensions. We are also polluters by consuming a lot of things beyond our requirements. So who is really accountable for that? See, these are open questions. I hope that some of the unanswered questions can be documented and circulated to the panelists for their reflection, should they wish to reflect. That will really help the younger people who are interested in these discussions. I would like to sort of, 3:15 is the cutoff time for this. I would like to sort of bring out some of the important things that we discussed today. I think one of the first and foremost things that we discussed is that everything is subservient to environment, and public health, both healthcare. Healthcare is essentially curative aspect of it. Public health is preventive aspect of it. More we care about environment, more we will usher in public health infrastructure. So that's a paramount thing, and everything should really flow from that understanding. So Supreme Court in this case must be a watchdog, an effective watchdog, and in doing so, it can only be an effective watchdog if it also plays its part, which it is duly mandated to also strengthen the subordinate judiciary. Rather than being apologetic about the workings of the subordinate judiciary, I think the higher courts need to step in and strengthen their capacity as well. The third important part that we've seen is regulation plays an important part, and many of the cases where health has regulation has not been adhered to, where regulators are supposed to have the expertise, and there's a tacit acknowledgement that both regulators as well as court systems can do better by referring technical matters to a group of experts, and such experts should be multi-stakeholder experts, essentially, so that a wider perspective is brought in. The couple of more points is that yes, the process of referring should be more of a norm to expert committees than an exception, and judgments like Shiv Shakti, sugar mills, etc., their essence should be taken in order to guide the judicial principles on economic and health and other aspects as well. The last thing that has come about is that there is a need, which I have already spoken about, there's a need to federalize the judicial, economic, and environmental and social thinking through the entire chain, rather than having a disproportionate expertise at different levels of judiciary. I think this requires a systems thinking, this requires a systems change, this requires actually many more discussions like these, and we hope we can actually federalize many discussions like these more in future, so that our expectation from each other are also get more refined alongside our understanding of the complexities that come along. On that note, again, I'd like to extend gratitude to JGU and CUTS International for organizing this. Vice Chancellor Professor C. Rajkumar, I've known you for some years, very, very able leadership. Thank you for organizing this. Been a pleasure. Thank you.
Hey, thank you so much, Abhishek, and thank you to Charu, and wonderful seeing you, Nupur, and thank you, Krithika and Tarini. So good that you all were part of this session. I really appreciate your valuable comments on this was a very important panel, and there couldn't have been a better panel to end this two-day conference as we move into the validity session. So thank you very much. We will be starting the validity session shortly on gazing the crystal ball, a step into the future. Dr. Montek Singh Ahluwalia will be delivering the keynote address, along with Dr. Frederick Jenny, Emeritus Professor of Economics from the Essex School of Business in Paris, will be delivering the validity address. So we'll take a short break and we'll be back in, say, 8 to 10 minutes. Thank you.
Sure.